Rent release clauses in Geneva's lease agreements often require prior tenant consent and cannot be imposed unilaterally by landlords, enhancing tenant rights and control over rental circumstances. At the federal level, Swiss tenancy law is primarily governed by Articles 253 to 274 Dream of the Swiss Code of Obligations, providing a uniform legal basis. These federal rules apply across all 26 cantons, ensuring core tenant rights are upheld, such as protection against landlord abuse and unfair terms. Cantons can introduce supplementary protections. Geneva and Basel-Stadt, in particular, have implemented specific cantonal rent regulations on top of federal law. Geneva's specific cantonal rent regulation is notably the LDTR, Loi sur les démolitions, transformations et rénovations, aiming to stabilize existing rents. The LDTR has complex effects, including stabilization of existing rents. This regulation is designed to prevent rapid, uncontrolled rent price development in the canton. Swiss law permits free rent determination but requires a maximum return principle. Landlords cannot exceed certain profit margins, protecting tenants from abusive rates. Rent increases over 10% at tenant change are considered abusive under Swiss law. Landlords must also provide previous rent details on official forms. Since October 2025, landlords in 7 cantons, including Geneva, must disclose previous rent and reference rate on an official form, else the rent is invalid. The mortgage reference rate, standing at 1.25% as of September 2025, provides a benchmark. Tenants can request a reduction if their rent exceeds this rate. Tenants have a strict 30-day window to challenge unfair rent increases or terminations at the Conciliation Authority, a crucial protection mechanism. Landlords cannot simply end a lease without cause. Terminations require proper form, timing, and justification, with multiple tenant recourse options available. Crucially, landlords who evict tenants for asserting their legal rights face severe legal consequences, reinforcing the tenant's power and security. On the tenant's side, punctual payment of rent is a fundamental obligation. Terms and conditions, including the due date, are typically defined in the lease. Tenants must also adhere to house rules, known as Hausordnung, which often specify noise restrictions, particularly during evenings, nights, and Sundays. Repeatedly violating these house rules can, in serious cases, provide landlords with grounds to terminate the lease agreement, even if other protections exist. The lease agreement is central, defining specific terms between landlord and tenant. It contains clauses that must comply with, but can detail, the legal framework. Any contractual clause less favorable to the tenant than the law provides is automatically void, even if signed. No pets clauses can be unenforceable. Similarly, clauses requiring repainting walls upon exit are only valid if the tenant painted them a non-standard color themselves. Normal wear is accepted. Unlike regions with no-fault evictions or at-will tenancies, Swiss landlords cannot end leases arbitrarily, requiring lawful justification and process. Geneva, like other cantons, has conciliation authorities attached to courts. They play a crucial preventive role, rapidly resolving disputes related to rent, defects, or terminations. These authorities deal rapidly with disputes, acting as a first step before potential court proceedings. They are integral to the practical application of tenant rights. Geneva also strictly supervises short-term rentals, like Airbnb, to preserve long-term accommodation supply for permanent residents, a unique cantonal measure. Reforms encourage energy-efficient renovations without justifying abusive rent increases. Tenants have the right to be informed of planned works and costs. The digitalization of the rental sector is progressing, with platforms facilitating procedures like concluding contracts or lodging complaints online. Discussions continue on rent controls in high-density urban areas to address housing shortages and ensure fair accessibility for lower-income households. Initiatives in Geneva aim to enhance transparency in rental relations. Projects focus on strengthening the subletting system for better clarity and fairness for all parties. Projects are underway to strengthen the subletting system, ensuring clearer rules and better protection for under-tenants while maintaining landlord oversight. Key tenant rights include the right to decent housing, protection against unfair rent increases, and a fair procedure in case of termination. In Geneva, these protections are reinforced by specific mechanisms like conciliation authorities, enabling rapid dispute resolution and stabilizing the rental market. Tenants have the right to be informed of actual charges and planned works, helping them avoid unforeseen costs and understand their financial responsibilities clearly. In case of disputes, tenants can call on local associations offering legal support and guidance through the rental process, empowering residents. Swiss tenancy law is highly protective, but most expats discover their rights only after a dispute erupts. Understanding these laws beforehand is key. Expats should proactively seek to understand what Swiss law protects and how to enforce their rights before needing to do so in stressful situations. Swiss courts consistently interpret ambiguous rental clauses in the tenant's favor, a principle ensuring that protective laws are applied as intended. Being informed about these specific Genevan and federal protections allows tenants to proactively engage in their rental agreements and assert their rights confidently. Geneva's rental market is not governed by secret laws, but a robust system of federal and cantonal regulations that ensures a uniquely secure environment. Understanding these legal nuances is vital for both long-term residents and newcomers, ensuring fair treatment and a stable living situation in Geneva. Knowledge of the Swiss Code of Obligations and Geneva's LDTR empowers tenants, transforming potential disputes into manageable situations through informed action. The principle of maximum return by landlords ensures rents are not excessively high. Tenants can contest rents that exceed these legal parameters, ensuring fairness. Tenants have multiple layers of recourse, from conciliation authorities to legal interpretation favoring them, ensuring their rights are robustly defended. Crucially, acting within correct timeframes is essential. The 30-day window to contest rent increases or terminations is a critical deadline for tenants. Swiss law automatically invalidates any clause in a lease agreement that is less favorable to the tenant than the law, regardless of tenant signature. Landlords attempting to unfairly evict or retaliate against tenants asserting rights face significant legal consequences, a powerful deterrent. Due to high population density and housing scarcity, Geneva implements additional measures. These include detailed information on previous rents to curb abusive increases. Tenants have the right to be informed of actual charges and planned works. This transparency helps avoid unforeseen costs and fosters trust. Recognition of tenants' rights is essential for a balanced relationship, ensuring fair housing, protection from rent hikes, and just termination procedures. The legal framework combines the Swiss Code of Obligations with specific cantonal rules. This dual approach ensures robust protection for tenants everywhere in Switzerland. This emphasis on tenant rights helps stabilize Geneva's rental market and protect the most vulnerable from abusive practices and unfair housing conditions. Swiss courts consistently interpret ambiguous clauses in the tenant's favor. This ensures that actual intent of protective laws is upheld during disputes. Tenancy law is based on the Swiss Code of Obligations, but each canton applies specific rules. Geneva's additions reinforce tenant safeguards significantly. Lease agreements define specific terms, but any clause less favorable to you than the codified law is automatically void, even if it's signed. This emphasis on tenant rights helps stabilize Geneva's rental market, offering a predictable and fair environment for residents, especially important for newcomers. Tenants possess robust legal recourse, including challenging rent hikes within 30 days and contesting unfair terminations with support from conciliation authorities. The detailed requirements for rent disclosures and controls aim to prevent abusive rent increases, safeguarding tenants from predatory landlord practices. In Switzerland, tenants have a fundamental right to decent housing, protection against unfair rent hikes, and fair procedures for lease terminations, all legally mandated. Swiss tenancy law is among Europe's most protective. Understanding these regulations empowers individuals to navigate the rental market with confidence and security. Challenging exploitative practices begins with awareness. Proactive engagement with rental agreements ensures tenants secure their rights before disputes escalate. Tenants can and should seek local associations or legal support to understand their rights fully. This guidance is invaluable for navigating complex tenancy laws. Geneva's rental market, safeguarded by layered legislation like the LDTR and robust federal laws, offers tenants a high degree of security and fairness. Don't let complex laws intimidate you. Understanding your tenant rights in Geneva empowers you to secure fair housing and enjoy peace of mind.